we'd like to invite John back up to take our questions. I don't know if I'm qualified to fill in his yellow legal pad, but there may be some of you who are. So John, would you rejoin us up front?
Please.
Any further remarks, or are we transitioning to Q&A and discussion?
I'm hoping to have suggestions and criticisms, please.
Let's go to right here.
I have a question. I usually can do this without this, but anyway. I have a question. I want to know the arguments pro on allowing the banks to invest in their own mutual funds. I just want to hear what they are.
Sure. There are, at the time that we did the restatement section that validated that, there were 47 states that had such legislation.
That they could.
Yes. So part of the decision that Hallback made in carrying that authority over is that restatements are supposed to tell you what the law is, and the law in most American jurisdictions had moved to that position. The legislatures didn't just wake up one morning and say, oh, you know, it'd be nice to authorize this. Where did that legislation come from? It came from a guy named Gene Maloney, who was in many respects an admirable and deeply pro-fiduciary figure. Died just lately at Federated Investors. Federated had a specialty in packaging mutual funds for smaller banks to offer. Federated ran its own mutual funds, but they also had funds that I think were they called private label. I forget the parlance here, but they had close involvement with the bank trust world. And Gene went into the legislatures and lobbied for that, as did others in the industry. But this obviously was the product of industry lobbying in part. What's the argument for the merits? That is to say, if Ed Hallback, if the 47 states had a statute saying that the bank trustees could loot the funds for their own good, he wasn't going to codify that. So the fact that it's widespread was not the only reason. There's an argument on the merits. What's the argument? The argument is basically this. If you go back to the beginning of modern trust investment by corporate fiduciaries, what you find is that they engaged in the construction of individual portfolios for each trust. So you'd pick 100 shares of IBM and 100 shares of AT&T and so forth, and in this way you would construct an individual portfolio. The trouble with that is that you were not able to get optimum diversification. Even if you had intelligent selection principles, the way this worked was the bank would have an approved list, and then individual portfolio managers at the trust level would work off that list to select stocks. But you'd wind up with a 20 or 30 stock portfolio in many cases because the trust wasn't large enough to get really optimum diversification. So step one was that the banks began to offer common trust funds. And that step was facilitated by a Uniform Act, Uniform Common Trust Fund Act of the even 1930s, but I could be misremembering it. And that act allowed the bank to construct a large portfolio, which would have, let's say, hundreds of stocks, therefore massively improving the diversification level. And then the bank would sell pieces of that in-house fund into the individual trusts. That's still a practice that exists. It's New York banks in particular have been very resistant to change. They like their common trust funds. There are difficulties with the common trust fund. It's not always easy to cash out. It takes a while. There are disclosure problems. It's hard to know today what your interest is worth because stuff has to get valued when there's no immediate market price. The mutual fund had the happy trait that it could be much larger than a common trust fund because it did not need to be limited to just the trust department assets. It could include assets from outside investors and therefore could be much larger, and that had the advantage of economies of scale in the construction operation of the fund. It also had the advantage that you would have daily disclosure to the market. There are a number of these operational efficiencies that caused mutual funds to become such a hugely important feature of investment organization. We forget how recent that all was. There was a regulatory story, which is the rise of the money market fund had to do with the change in allowing check writing and the like with the Dreyfus Fund back in the I think it was in the 70s. So the mutual fund industry has become the dominant mode of investing at the retail level for small, meaning well short of great wealth investors. And as that happened, it became attractive to the banks to consolidate those operations into a single type of offering. There was an important change in the tax law in 1997, I believe, which allowed the conversion of bank common trust fund interests into mutual funds without recognition of the gains. So that rollover treatment facilitated this. So I guess what I'm saying to you is there are some substantial reasons why. Well, you could, but then you're basically defeating the settlor's intention. The settlor said, I'm leaving my money for my kids and I want Bank of America to run it. And what you're telling the settlor in that case is, you can't do it. And we didn't want to go there. We just, the legislation requires disclosure. It's annual disclosure, if I recall, in the Uniform Trust Code version of the potential conflict. And there's some of these jurisdictions, these statutes have restrictions on the compensation and the like. Others have disclosure about the compensation. It's not pretty. This is not an easy question. I do think that in circumstances in which you have a fund, the bank's running some mutual funds, and one of them hasn't been performing very well. My advice to the trustee is shoot stragglers. Make sure that you exit some of your own funds that over the long haul have not done well or don't go there in the first place. And it's been a trend in contemplation of all of this for trust instruments to provide what the industry refers to as open architecture, which means there's express provision for using funds from non-affiliated providers.
Bob is next.
Okay, thank you, John. So let me offer three comments in response to the question you've asked. So the first was, you talked about disclosure and petition for instructions. You can imagine them being on the same spectrum, disclosure at one end of a spectrum, petition for instructions being at the other end of the spectrum of super robust disclosure. And you've talked a bit about the weaknesses of each. So one place you might look as you think about solutions or improvements would be, I understand that California and maybe a couple of other states have adopted a statutory notice of proposed action for trustees, which is a formalization of disclosure that is more formal than a simple disclosure, but not the robust bells and whistles and expense of a petition for instructions, but would give some protection to the trustee and acting under it. So this may be the best of both worlds or the worst of both worlds. That's a place to look for solving. That's one category. Okay, a second comment is about the suggestion that the trustee maybe look for independent legal or maybe financial advice, but the difficulty there, then the trustee's making that choice. So the two comments or ideas for you there. One would be to look at corporate practice, which has a best interests loyalty standard, and to what extent are corporate board practices, when conflicted, translatable to a trust context. You may not have a board of directors, there may not be independence, there are all sorts of things that will not be translatable, but the basic idea of procedural and substantive fairness and evidencing procedural and substantive fairness by outside advisors is a place you can look. And it might be, you separated prudence, right, that the trustee still has a prudence obligation. You could bring prudence back into this, that there's a prudence obligation in how you get this outside legal and financial advice or test the market. So that's a second category, curious reactions. Okay. And then the third, I said there was three, was about disclosure. Maybe this brings it back to the first. So I'd be curious to think a little bit about disclosure, petition for instructions, this California innovation of notice of proposed action, and another landmark on that spectrum would be just a straight up consent and release from beneficiaries, in which we also build in procedural and substantive safeguards by requiring the beneficiaries to have an understanding or some kind of disclosure. It's a common practice among banks to say we want the beneficiary to have independent counsel, which brings in independent counsel, but a beneficiary choice and not another. I'm not suggesting any of these are panaceas. I mean to suggest them as things you might add to the menu and think about where to locate them and how maybe that fleshes out the project.
Beneficiary consent in trust law is hard because trusts are commonly dynastic and you're dealing with minors or indeed unborns. And as a result, you then have to get a substituted decision maker, and those are hard problems. You mentioned the procedure in conflict cases in corporations. I was tempted to discuss that in this little paper, and I may yet, when I revise it, get in there. Let me say that there's a huge difference in the expected structure of the fiduciary in trust law and corporations. Trust law, the tradition, as I said earlier, is my brother-in-law. It is a single person, unitary trusteeship. Later on, it becomes my friends at Bank of America. It's a corporate fiduciary, but it's a single actor. The corporation typically has a board of directors with many people. It doesn't have to be, but that's the norm. And as a result, what's open to a conflicted officer or director in a corporation is what is now the normal drill or protocol. The conflicted director shows up and says to his fellow directors, the transaction that you're now considering is one in which I am interested. That property that you want to buy actually belongs to me or my wife or something. So A, disclosure. B, non-participation. The conflicted director has the opportunity to stand down, and that is recommended. That's the norm. So you give notice and you don't participate, and you leave it to your fellow trustees to make, your fellow directors to make that decision. We can't rely on that device in trust law because it's all too often the case that the conflicted trustee does not have fellow trustees, does not have co-trustees. And it's the expectation of unitary trusteeship that makes it hard to emulate the corporate solution. This corporate solution works pretty well, and we have not been able to map onto it in the trust world for the reason I've indicated.
Next question. I go next?
Yes.
I wanted to make a suggestion that perhaps you should just focus on corporate trustees, professional corporate trustees. The family example that you started with seems a little bit, to me, too easy to resolve. We all know that the sole interest of the beneficiaries includes all the beneficiaries of a trust, including the beneficiary who happens also to be a trustee. And we're rather confident that that's worked out rather well and is not so hopelessly conflicted as you think. I think that comes from the fact that, for me, a lot of thinking about fiduciary duties comes from thinking originally about a family with small children, parents and small children, and how sometimes the law has to step in when the family members, the parents are deceased, and they have to take care of beneficiaries, but beneficiaries who are helpless and incapacitated. Every parent with minor children is hopelessly conflicted. I can spend money on my children, or I can spend money on myself. We don't view this as a pervasive problem that needs, ALI to step in and resolve it. The families somehow raise their young, even despite this hopeless conflict. That's because every parent, I think, understands the sole interests of the children are what guides the parent. Self-interest.
That's not right. It is what guides the parent is in part the interest of the children, but also the interest of the parents. And as a result, you're in a balancing situation from the get-go. There's perpetual conflict. It's ubiquitous. How much of my time, my love, my treasure do I pour into my children? And what about what's left for me? May I keep back some time to go to the opera and so on?
You're right. The problem of the beneficiary who's also a trustee is similarly adjusted, I think, in all the ways you just said. If the trustee is the brother-in-law, then you start to worry, well, a spouse trust beneficiary might be favored more, but we still find that easy to adjust. It's only when I jump to the professional corporate trustee, your friends at Bank of America, that I see them not regarding the beneficiaries in the position of a family member or a close friend of the family as helpless, incapacitated, or just simply weaker, more in need of protection individuals, but starting to think of them like the customers of the bank, the customers of the trust company, in the way that you've depicted throughout this, as we can't trust them to seek independent counsel because they'll be selfish, greedy, grasping, and corrupt in it for themselves. For some reason, we're able to imagine trustees who don't do that, and I think that's the puzzle that I still have.
I suppose the law and economics folks would talk about reputational incentives on the part of bank or other institutional fiduciaries, in part as a response to this notion that you're developing. It is true that institutional fiduciaries don't have a direct personal interest in the well-being of the beneficiaries, but they do have a direct personal interest in not getting their tail sued off, and in the reputational concern that continued new business will come through the door if they're not known to be abusive. I've had various dealings with bank trust departments across 50 years or so, and I think that there's a genuine concern on the part of many of these folks to do the right thing. I also think that you can't rely on that. There's a lot of there are very serious staffing problems with bank trust departments. It is amazing how often somebody winds up in a trust department because he's been kicked upstairs from the commercial division. They don't quite want to fire him, so well, we can put him in a trust department. There is an amazing amount of turnover in bank trust departments. It's a kind of what is it? It's the Peter principle. When somebody
Promoted to the level of incompetence.
yeah, when somebody's competent, you tend to promote him up until he isn't. There's an enormous amount of turnover. Compensation levels are not particularly good. It's a strange world. There's no orderly career line. You don't. I never met anybody in all my years in ritzy colleges and universities. I never met anybody who thought he wanted to be a trust officer. You never hear the career. People who do it are typically ex something else. Ex trust and estates lawyers or ex commercial bankers. And there are a couple of proprietary training outfits that the Canon organization, and there's another one that purport to run training courses for trust officers. But I don't have any sense that there's an orderly, attractive career line. If you don't have that, you don't have the circumstances you ought to have. So I don't mean to say that I think bank trust departments are in any sense perfect. I think, however, that if we didn't have them, we'd have to create them. They fill a real need, and they, on balance, do it pretty well most of the time.
We're next coming over to your left.
John, I feel sorry for the aspiring young trust officer who decides to consider whether the bank's trust fund is the best one to use or some competitor's fund is a better one to use. And they do some analysis, what's the greater rate of return, or the safety factors, are there social investing concerns involved, and decides that the other bank's fund is better. Is that going to be a good career path for that trust officer to present that proposal? Or is it going to be the one who's advanced who says the bank's fund is the best? And I just think that is such a flat-out encouragement for disloyalty, that it should not be encouraged. That's where you and I have one of our few differences over the years. I wanted to make one other comment on your question about the checklist and the question of getting judicial countenance for what you're proposing. And you mentioned the time constraint. There's another constraint that has to affect a trustee in considering that, and that's the expense of any judicial proceeding, which would be, and that's a matter of culture. But I can tell you true story, and this has happened more than once in my practice. Upstate county will say either New Hampshire or Vermont, I'm discussing with local counsel a particular issue. I inquire, how does the local probate court feel about that issue? The local lawyer says, I don't know, I'll go over and chat with the judge this afternoon about it. And that's happened to me more than once. So that's an informal way of doing it.
If you can get there. Yes.
Deborah, I think you had your hand up next.
Excuse me, I'd like to follow up on the last question, or an implication of the last question. Sometimes the law or regulation can be very helpful in stiffening the spine of people within organizations who need to make difficult decisions and who can otherwise fear the repercussions for themselves within the organization. So, I mean, one implication of the last question is that trust law or other regulation is not doing enough to stiffen the spine or help stiffen the spine or help support the decision making by the individual trust officer. I mean, one way the law might do that, as in corporate law, at least in California, for not-for-profit corporations, is making it very clear that the terms of the conflicted transaction overall need to be at least as good as an unconflicted transaction. Now, nowadays, too, I would think that kind of legal standard could be part of the trust department's compliance protocols. It could almost lend itself to a checklist. Have you checked? You know, are you sure with this? And then, you know, for the individual who is otherwise fearing internal repercussions, as is oftentimes true in lots of organizations, like broker-dealer organizations or investment advisors, the law can be helpful in making, in helping, I said stiffen the spine, or helping make reputational concerns, long-term reputational concerns, more vivid or more evident.
I think when you're dealing with investment matters, the range of considerations is substantial. You're trying to decide what is the appropriate risk tolerance of the trust or the beneficiaries of the trust. You're trying to see whether that matches the risk level of the investments. And you're also concerned with things like the need to produce income, and with liquidity concerns and the like. A good procedure in a bank trust department will be to have a rule that you create an IPS, an investment policy statement, which identifies the beneficiaries and their needs and risk tolerances, matches that to investment practices or objectives, what kinds of assets seem to look right. And then, most importantly, that's a document to which you come back to every 6 months or a year for benchmarking purposes. How are we doing? If a particular fund is underperforming, you may want to keep it for a while, but if it underperforms your expectations and the purposes for which you bought it, at a certain point, you're likely to want to rebalance, as they say. You're going to dump it, even if that results in tax consequences. You want to go ahead and put your money someplace else. So the duty to monitor, which is part of the prudence rule in investment matters, will lead you to a pretty steady review of initial decisions. So that bank trust officer, investment officer, who made the cowardly decision that Ray is worried about to buy the inferior product, he's got a duty to come back and look at his handiwork very often. And as a result, and he knows that, he has some incentives not to be as cowardly as Ray worries about. Furthermore, having a principled explanation for why you don't want your own product in this case, namely that it's got too much Brazilian bonds or whatever. There are reasons there, and you give reasons, you put them in the file, and it's principled, and as a result, you'll be protected. You'll look good doing the right thing because you're going to protect against liability. Being cowardly can get you sued, and the bank doesn't want to get sued. So it's not an easy choice. But I think Ray is right. There is a point at which there are career incentives that cut against optimal decision making in this area.
Has there been a movement among bank trustees to migrate towards the use of index funds as a preferred choice for investment vehicles? Because it would seem to me that an index fund is the ultimately appropriate fiduciary choice for someone to make, and it removes the career concern that someone might have about potentially making an inferior choice.
Indexing has now become the dominant mode of portfolio construction. We now have slightly more than half of investment assets in the United States held in indexed vehicles. I think that's equities only. There are passive indexes as well for bonds, but that's a much harder field for various reasons. Bank trust departments are involved in this. They either index, or they can go out on a street and buy State Street's or Vanguard's index product, or now what's the BlackRock is the dominant house now for these externally managed index funds. These vehicles are easily available, and most corporate fiduciaries are aware of their importance. The restatement, which was drafted effectively in the late 80s, when indexing was just getting going, the restatement has a discussion of the choice between passive and active investing. And it's not all that elegant, but it does say we have thought about the question whether there's a duty to index, and we have decided not. One reason is because we're just coming out of a world in which trustees were mandated to invest in a relatively small number of things, which turned out not to be very smart. The rule had been well-secured first mortgages or government paper, and that meant that you were exposed to the ravages of inflation. We're still fixing the roof on all the buildings at Yale from the years when our endowment performed so badly because it was regulated in this way. So one reason that the restatement took the position that they weren't going to mandate indexing is that they had come to a different principle, which is we're not going to mandate anything. And so one of the key things which we did in the restatement and then in the Uniform Act is to say there are no categoric exclusions with respect to investment assets. In principle, you can invest entirely in Tsarist Russian bonds and Polish zloty futures. Now, if you do, chances are you've got a prudence problem, and your chickens or zlotys, whatever, are going to come home to roost, and it will not be successful. But we're not going to stand at the front door and tell you you can't do it. What we're telling you is you have to be prudent in whatever you invest in, but we, the legislature, aren't going to tell you what you can invest in. So that was part of the reason for not going there. The other concern was that nobody knows to what extent the inherent free rider principle in indexing will become problematic. The reason that index investing works is that there's enough active search out there correctly pricing those securities so that the rest of us in index vehicles can simply free ride on the market prices that those securities achieve. If everybody were to index, then it would cease to be efficient and their opportunities for positive returns would emerge. Another feature of index investing which causes one not to want to mandate it is that when you get off into areas of the markets which are less efficient, meaning there's less active search going on, there's been more experience with alpha, with successful active investing. That's particularly true in the small cap area. Small cap stocks are not followed by very many analysts, and your chances of outperforming are a little better there. So there are reasons for not mandating indexing, but the advantages are enormous. The economies are huge, and whenever I look at somebody's trust account and part of it is not indexed, I regard that as deeply suspicious. Have I answered your question?
You've answered it, although I would challenge you on your assertion that small caps are somehow less efficient and there's more alpha available there. I've yet to see the evidence of that.
I don't follow the measurement literature closely enough to know whether there's still anything to it or not. Rex Sinkfield founded a company which became hugely successful called Dimensional Fund Investors, Advisors, and the whole thrust of that operation was focusing on small cap. And for a long time, it seems to have worked, and I have to say I haven't followed it lately.
John, behind you here.
Boo. I don't know if this works. Question I have is on common trust funds, collective funds. I actually appreciate what you said about them, and I'm curious because in the literature out there, it appears that there's a trend within the 401k environment to move towards collective funds, primarily because they cost less than mutual funds. And I was just wondering if you could comment on that, why that might be the case, or if there are other issues that people are ignoring with regards to collective funds versus mutual funds.
I am going to just admit that I'm not close enough to current practice to have a feel for what that's about. I'm aware of the fact that there has been some renewed interest in common funds. And in particular I forget the precise name of it, but it's a fund that is designed for a particular large investor, pension fund or whatever, and where you are staying away from the compliance costs associated with mutual funds.
Two things sort of in relation to mutual funds and trustees and the way that they would invest in them. What is the factor that specifically the fee part of purchasing mutual funds, active funds as opposed to passive funds, as he was discussing, play into the analysis of the prudence of a specific fund? Because I am imagining that the trust banker who is looking at the funds at his own company, they may perform well or not, but that I know from the research, at least as I've understand it, that I've done, the fees can be one of the biggest things that makes something either a prudent investment or not a prudent investment. And then and secondly, the issue of the free rider problem for index funds. While on a sort of macroeconomic scale, I kind of understand that concept. It does seem like from an individual trustee's perspective, though, their duty is to, for the returns of the beneficiaries, sort of, and to hopefully kind of just ignore the possible macroeconomic implications of their decisions.
You don't want to ignore anything when you're a trustee that might be relevant to performance, and the possibility that an index strategy might cease to be as effective as it has been is a concern that worries a lot of people who do portfolio management. Fees, yes. A core rule of trust law, which we codified for investment purposes in the Prudent Investor Act, is that a trustee has a duty of cost sensitivity. You have to pay attention to costs. You don't leave free money on the table. If you can get something for less, which is identical or close to identical at another shop, you go there, and so forth. And in the most of the mutual fund authorizing statutes, there is an express requirement of disclosure of cost differences.
I'm going to take the last question. You're a man of tremendous accomplishment and stature.
Uh-oh.
And yet I have found
being set up.
one thing you and I have in common. We both have served as trustees of a remainder trust, I'll call it. Before my father passed, he created a trust to take care of the needs of my mother for the duration of her life, with any remainder going to their children, their 7 children. He named me as trustee. Lucky me. Your remarks were very insightful around the conflicts, the structural conflicts inherent there. You touched also on naming instead a corporate trustee, which would of course charge for its trustee services, but would remove that structural conflict. That said, there's also a charge to the trust for those corporate trustee services. So how do you balance those two against each other?
You do. That is to say, what you are deciding in the choice to have a corporate trustee is, do I want somebody who has direct personal knowledge of the beneficiaries and their needs, or do I want somebody who lacks that? Sometimes you don't have to face that choice. You can do both. You can have co-trustees and then characteristically you divide the functions so that the bank does the custodianization of the assets, collects the dividends and interests, does the financial accounting, prepares the tax returns, and so on. But you, the individual trustee or trustees, will have the discretionary decision authority, how much to pay to mommy, how much to hold back, and so forth.
Okay. Thank you. And I thank you for your remarks today.
Please.